Hello everyone, my name is Isaac and today I'll be talking about the beneficiary principle and how it is unnecessarily rigid. First and foremost, we must understand the concept of beneficiary principle. It mentions that in order for a trust to be valid, there must be an identifiable beneficiary who can allow it to be enforceable. The principle is often conflicting with non-charitable purpose trust, which is created neither for the benefit of a human beneficiary or to serve any charitable purpose. The beneficiary principle is recognized in Malaysia based on the adopted common law framework on the English equity jurisprudence. The case of Morris and Bishop of Durham laid down the terms of the beneficiary principle, where the trust in the case was not a charitable trust and the beneficiaries could not be identified. The trust must have a definite object and some person for the court to decree a performance. The trustees would be held accountable should there be one with a beneficiary interest. However, in modern times, it is seemingly evident that the principle is unnecessarily rigid and constantly drawing criticism. The rationale behind the beneficiary principle is to ensure that the trusts are enforceable. The principle further creates a distinction from mere moral obligations. For instance, in the case of Ray Astor's settlement trust, the Astor family had set up a trust of the majority shares in the Observer newspaper that they owned for various purposes such as promoting good understanding, sympathy between nations, and high standards of journalism. Justice Roxburgh held that the trust was void as there were no ascertainable beneficiary. Richard Clements and Ademola Abbas, in their book Complete Equity and Trust, had commented on the case in which the trust must be clear in order to be enforced and questioned how sympathy between nations could be enforced. One thing to note from the case is that it mentions perpetuity, which brings to another rationale. The beneficiary principle plays a crucial role in avoiding perpetuity. Perpetuity is known to tie up trust for an indefinite period. The beneficiary principle is a safeguard against perpetuity, where it involves the remoteness of vesting of beneficial interests or prevents the trust from being perpetually inalienable. For the former, it ensures that there are no delays for a long period of time in identifying the beneficiary who obtains the trust property. On the other hand, the latter plays an important role for a property to be allowed to be freely circulated or traded and not locked from the market for too long. In the case of Rain Notage, it was held that the prize was not for a charitable purpose and was void as it was a perpetual trust which would hold the sum for an indefinite period. The adaptation of the rule against perpetuity in Malaysia was seen in the case of Chua Chun Neo and Spottiswoode, where the rule against perpetuity did apply, particularly in the Strait Settlement at the time. It was reaffirmed by the Privy Council in the case of Yap Chia Neo and Ong Cheng Neo. It was once again tested in the case of Pan Kin Tin and Pan Kuan Yung, where a bequest for the father's ancestral religion was valid as non-charitable purpose trust, as long as it did not violate the rule against perpetuities. It must be emphasized that although beneficiary principle is separate from remoteness of vesting or rule against inalienability, the rules against perpetuity provides as an additional and distinctive requisite only should a human beneficiary exist. The beneficiary principle complements the rule against perpetuity by ensuring enforceability and temporal limits. Next, the principle functions to prevent the creation of abstract purpose trust. Abstract purpose trust is defined as a trust to fulfill a certain purpose rather than benefiting specific individuals. The court's rationale in adopting a rigid approach towards purpose trust through the beneficiary principle is to ensure that there would not be legal uncertainty or unregulated usage of property. In Ray Astor's, the court held that the trusts of the income were not valid, as it was too vague and not for the benefit of individuals, but for several non-charitable purposes. However, the beneficiary principle would not prevent all abstract purpose trusts and could still be rendered valid in a very technical way. In the case of Leahy and Attorney General for New South Wales, the testator bequeathed his sheep farm with a small homestead to the Order of Nuns of the Catholic Church. The Privy Council held that the gift to the unincorporated association, like the religious order, must be defined carefully. The bequest was not an outright absolute gift, and based on Section 37D of the Conveyancing Act 1919, it was valid. Viscount Simmons had stated that if the purpose is non-charitable, then it would fail under the beneficiary principle. Although the beneficiary principle is known to be rigid towards non-charitable purpose trusts, as explained earlier, the courts have taken a more flexible approach in circumventing its rigidity. The case of Ray Danley's trust deed provided a sense of flexibility in circumventing the already rigid beneficiary principle. Justice Goff stated that although the trust was in a form of purpose, it benefited some ascertainable beneficiaries and is not void. It was in the form of people's trust. This case gave a better understanding of the circumvention of the beneficiary principle. in which if persons availing a benefit from a trust holds an immediate and genuine interest as well as having the locus standi, it will be considered a valid trust. The beneficiary principle could also be circumvented should the purpose of the trust attached being an absolute gift. In the case of Rei or Soba, the court held that the trust was valid as it was a gift with special purposes to the three individuals. This case had applied the principles of Ray Sanderson's trust, in which where the trust is created for both beneficiaries and a stated purpose, the court would declare it as the arrangement for an absolute gift to the beneficiaries, with the purpose regarded as not a binding obligation and merely a settler's motive. In such cases, the purpose is considered optional and does not affect the enforceability. Last but not the least, the rigidity of the beneficiary principle is seen to be circumvented if the contract holding theory is applied. The circumvention of the beneficiary principle via this perspective is rather complicated and vague, and case laws often relate this to unincorporated associations. In the case of Conservative and Unionist Central Office and Burrell, the court was to identify whether the Conservative Party was an unincorporated association and was subject to corporation tax. Lord Justice Lawton explained that unincorporated association meant that two or more persons are bound together for common and not business purposes. The bond of union in such association has to be contractual. However, no contract could be found and no trust arose. Lord Justice Brightman further explained that for a party to operate as an unincorporated association with clear membership, rules and contributions made to the party is held to be under contractual agreement between its members. His Lordship further related this with an authority such as Ray Ratcher's Will Trust, where when express trust language is absent, a legacy made to an unincorporated association is understood to be a beneficial gift to its members and governed according to the members' mutual contractual agreement. This avoids the need for the trust to be understood to be a gift, governed by contract and not a trust obligation. However, in Ray Ratcher's, the gift was void as the society had been dissolved. Thus, if the courts adopt a contract-holding theory, it circumvents the need for enforceable equitable rights, as it arises from contract and not trust law. Now, we shall discuss the exceptions to the beneficiary principle. The principle does not extend to non-charitable purpose trusts that are anomalous and have exceptional concessions to human weakness or sentiment. As briefly mentioned, it could stand as an independent exception is the presence of an unincorporated association. Such associations do not have legal rights and are unable to own a property on its own. The association's members' property is owned depending on the terms of the gift and the constitution or rules of the unincorporated association. Neville Estates Limited and Madden explains that a gift to a non-charitable unincorporated association can be valid, but not as a purpose trust, but as a gift in favor of the present members of the non-charitable association as joint tenants. A Ray Denley tried trust, or as the aforementioned contract holding theory. This was followed in the case of Ray Holytown Football Club. The case highlighted an exception to the beneficiary principle, because the trust in a traditional sense did not have a clearly defined and enforceable beneficiaries. The trust was deemed valid based on the internal rules and purposes, which is seen as an exception to the rigid beneficiary principle. Another exception would be if the trust is charitable. This trust is distinguishable compared to non-charitable purpose trusts, as the prima facie for non-charitable purpose trust is that it would fail due to the lack of human beneficiary. Charitable trusts are deemed valid as it forms as an essential part of social welfare provision in societies. The landmark case in the field of charitable trusts is Commissioners for the Purposes of Income Tax and PEMSL, where Lord McNaughton stated that charity in the legal context consists of 4 principal divisions, which is trust for the relief of poverty, advancement of education, advancement of religion, or other purposes beneficial to the community. The PEMSL case was adopted in Malaysia as seen in the case of Ray Abdul Ghani Abdul Lasa. Here, the gift for the recital of prayers was a valid charitable trust created for the advancement of religion. In understanding anomalous exceptions, this exceptional grounds often arises out of human weakness or sentiment as asserted in Ray Astor's. The case of Ray and the court had further laid down the principles of this exception, in which Master of the Rolls Lord Evershed had decided that although the gift was not a charity, it could still be valid. He further stated that there could be a trust of a public character but not a charitable one, which renders it to be anomalous. It could fall into 4 categories. Firstly, as per the maintenance of monuments or grave, the anomalous exception to the beneficiary principle could be seen in the case of Chiang Tiu Mue and Chiang Nyo Lian Nyo, where the court held that the of the trust made the trust to use the land as a private graveyard for the persons belonging to the set or tribe called Chiang was valid as there were people benefited by it. This case showed that there is an emotional rationale and sufficiently specific. However, the rule of trust on monuments and graves is not generally stable, as in the case of Li Po Lian Neo and Chinese Bankers Trust Co., as it was affirmed that the trust was valid and the deceased is entitled to be buried in the burial ground according to Chinese custom. The court further stated that it is difficult to justify the case via conventional trust law. Secondly, for the maintenance of specific animals, the authority would be the case of Pettingal and Pettingal. The testator had made a bequest in his will where his favorite mare would be paid in order to be kept in a park. The court held that the trust was valid, as there are beneficiaries to enforce the trust and inherit whatever is left after the mare is cared for. The next anomalous exception would involve the saying of masses. For centuries, the court had been reluctant to enforce such trusts, as they regard it as superstitious. The authority for saying of masses would be the case of Ray Hetherington, where prior to this case were not regarded as religious charities, even in Bond and Keene. Ray Hetherington accepted that such trusts are charitable and valid, provided the public could attend the masses. However, for private causes, it is only valid for exceptional circumstances. The authority, which is Ray Kru Cheng Teo, stated that private ceremonies could be recognized as non-charitable purpose trusts if it is restricted within the perpetuity period. This case exemplified that non-Christian ceremonies could also be a valid purpose trust. Another anomalous exception to the rigid principle, which is miscellaneous, has a rather odd stand as seen in the case of Ray Thompson. The testator gave a legacy to a friend for the promotion and furthering of fox hunting with the residuary estate given to Trinity Hall, Cambridge. The judge was convinced that the trust was valid and could be enforced by the court or Trinity Hall. Hence, the aforementioned categories serve as an exception, although it does not comply with the rule that a human beneficiary must be present. Despite the various circumvention and exceptions available, the rigidity of the beneficiary principle is still present, and it is evident that courts are not completely prepared for a more flexible approach. The first consequence of the principle's rigidity is it creates a frustration of the settlor's intention. When the settlor dedicates the fund to a non-charitable purpose, it may fail unless deemed charitable by the courts. This curtails testamentary freedom. Next, the principle's rigidity creates a sense of uncertainty as to the development of the trust law involving beneficiaries. When the language of the trust is structured in a way which is vague, it would be up to the courts to identify whether it would fall as an abstract purpose trust or could it fall as a trust as established in Ray Denley. Thus, a sense of confusion in the law would further complicate the concepts of trust law. Finally, the rigidity of the principle creates an over-reliance on charitable trusts. As the law seems more keen with charitable trusts, there would be an influx of trusts based on the charitable trust frameworks, which comes with limitations such as oversight by the Attorney General, as per Section 9, Subsection 1 of the Malaysian Government Proceedings Act 1956. This may cause the misuse of charity in order to be legally enforceable, which potentially disrupts the charitable sector. One of the reforms suggested would be to broaden the Ray Denley's exception. As mentioned initially, although ruling of this case benefited individuals, it was in the form of a purpose. It is suggested that the courts could further the Ray Denley doctrine in order to include indirect human benefit or community-based purposes, which traditionally courts would often rule out. The second reform would be to have a statutory recognition of non-charitable purpose trusts. Such an act will allow a non-charitable purpose trust to exist, provided that the purpose is ascertainable and that there is an enforcer similar to the Attorney General for charitable trusts. This would allow the terms of the trust to be upheld. The final suggested reform would be to expand the definition of beneficiary. The definition must be broadened to not only include individuals with proprietary interests, but also those with substantial personal or communal interests involving the trust. This would render the beneficiary to be less rigid and more inclusive. In conclusion, despite the beneficiary principle being central to trust law and ensuring that obligations of trusts are enforceable, its rigid application, particularly to non-charitable purpose trusts, has undermined the modern trust usage and settlor's autonomy. Although judicial flexibility as seen in Ray Denley exists and approaches to circumvent and exceptions being present, there are still unnecessary limitations existing that affect the legal development of trust law. Thus, reforms such as the ones suggested previously are monumental to foster justice and public benefit within the framework of modern